Hello and welcome to our lecture on economic substantive due process. I'd like to encourage you to go back and look at the government neutrality and police powers lecture that I gave, because those concepts are going to play out here and they're going to be very important, and that lecture gives you a good grounding, will really help you as we move along, talk about these cases. Okay, so just to give you an overview of what substantive due process is. Due process is an ancient concept. It's a lot like police powers. It predates the United States Constitution. We can find it mentioned as early as the 14th century in documents in Britain. So the concept of due process has been around for a long time, and its initial meaning was procedural fairness. In other words, whatever government does to you, it has to follow certain procedures. Later, we began to read due process to mean the protection of substantive rights found in the freedom of individuals. So not only does government have to use proper processes, but they have to respect certain aspects of your life and leave those relatively unregulated unless it can find a public health, safety, welfare, or morals justification. There it is, folks. There's government neutrality and police powers. Very closely related to due process. So the court used this interpretation, this substantive interpretation of due process, from about the 1890s to the 1930s to interpret private economic rights found in the 14th Amendment, and then to limit state power. I want to stop just for a moment and point something important out. Just to connect the Commerce Clause jurisprudence with the substantive economic due process jurisprudence. So the Supreme Court was all about limiting federal power under the Commerce Clause. If it's not commerce, Congress can't regulate it. Who can regulate it? The states. Okay, so then the states regulate, and the court goes, you can't interfere with private contracts. So let's think about this just in terms of Darby Lumber or Carter versus Carter Coal. Okay, so the federal government wants to stop child labor. I'm sorry, not Darby Lumber, Hammer versus Dagenhart, and Carter versus Carter Coal. The federal government wants to stop child labor, and it regulates goods that are in the stream of commerce and says these goods that were produced by children, they can't be here. Court says, nope, I'm sorry, you can't do that because manufacturing is not commerce. And it's local and intrastate, wholly intrastate in concern, and only the states can regulate. So the states go, great, we're going to regulate manufacturing by limiting child labor. We're not going to get rid of child labor, but we're going to, limit the number of hours that children can work and try to improve their working conditions. And the court comes along and goes, you can't do that. Unless you have a public purpose in mind, you can't interfere with private rights of contract because contracts are like property. Wow. Think about that for a moment. The court said, federal government, you can't regulate, can't create a national policy. So the states regulate, and the court goes, nope, you can't regulate either. This frustrated people. This approach to our Constitution created tremendous frustration, especially during times of economic crisis. It seemed like the court was more concerned about not allowing government to meet these crises and these emergencies than to reading the Constitution structurally to allow governments, whatever government, to do so. All right, so why we study substantive due process? Its rise and fall is an intriguing history. It is an intriguing history. It's important to understand. I think we've really lost sight of why there are unions. Everyone seems to be anti-union these days, and they don't know why. And they have no idea what purpose unions served in the past. Like any human institution, it's rife with problems. There will be problems with unions, but getting rid of them altogether seems to be a bad idea, especially if you want to empower workers and make certain that people are taken care of. Also, substantive due process allows us to study judicial activism. These were conservative courts here in the 1890s to the 1930s. They were conservative in their orientation, and they were also extremely activist. They were striking down federal regulations and striking down state regulations. So I think it helps us to explode this idea that conservatives are restraintists and liberals are activists. It's a false distinction, because the very first activists, the ones that went about striking down laws willy-nilly, were conservatives. The liberals picked up on that in the 1940s, 50s, and 60s, and with respect to civil rights and criminal rights. Also, it allows us to examine cycles of history and law that we have seen in other areas. This is really important to understand where we've come from and how laws have developed over time. And also, it has relevance for today in a couple ways. We're encountering a changing economy, and we're not certain how government is going to keep up with it, whether it has the tools to do so. Instead of criticizing government, we ought to be thinking about giving it the tools, the proper tools under the Constitution. It also has relevance for today because, as I said before, this is exactly the machinery that people have used to protect civil rights. So we're going to be talking about how the court has attempted to protect economic rights, and that changed in the 1930s. And then after the 1930s, the court used exactly the same kind of logic to protect civil rights. All right, so our first case we want to talk about today is Munn versus Illinois, decided in 1877. This is discussed in your text. And this case involved grain elevators. We talked about it a little bit in an earlier lecture. The grain elevators, they were very much, the people who ran them were very much like the people who ran the stockyards. They were all about charging as much money to the farmers as possible, and making as much money for themselves, sometimes engaging in fraud in doing so. The state of Illinois moved in and said, okay, from now on, you don't set your own rates. The state sets them for you. Munn, who operated one of these grain elevators, sued because he said that was an infringement of a private contract that he made with the farmers who were paying him to store his grain. And the court ruled, it asked the question, when private property, like grain elevators, affects the public interest, it ceases to be juris privati only. In other words, it ceases to be private property only and can be subject to public regulation. So in this case, a very conservative court upheld the state regulation and said that the state of Illinois can regulate these grain elevators and grain storage companies because they were engaged in defrauding the public. They go on to say those regulations are interferences in the right to contract. They're not neutral, right? They're not neutral. So they violate the principles of government neutrality. But it's okay because they are justified by the state use of the police powers to preserve public health, safety, welfare, and morals. There we go again. There's government neutrality and police powers. In a case called Allgaier versus Louisiana, the court states that the mere fact that a citizen may be within the limits of a specific state does not prevent his making a contract outside its limits while he himself remains in it. Here, the contract was valid even though it was made outside the state with a party who was within the state. So this case dealt with making a contract of purchasing an insurance policy, and the state of Louisiana was attempting to regulate the insurance industry because they were also causing fraud. And they attempted to negate this insurance contract and saying you can't purchase insurance from companies incorporated outside the state. The court struck down that Louisiana regulation, saying that a citizen has a right to make contracts with companies to get the best rate possible. I think I'm going to take a break here and start the new lecture with Lochner versus New York as substantive due process, part 2. Be right back.